Hello, welcome back. Brian Sullivan, President, Nassau County Correctional Officers Benevolent Association. One question that came up several times from our members is that they were getting notifications if they were out waiting for test results or positive from COVID, that the department was notifying them of their test results. And the question came up is that proper protocol? Does that violate HIPAA regulations? And so we decided with our attorneys that we were going to delve into this and find it exactly, because this being a worldwide pandemic, does that change the rules? And to our surprise, yes, it does. I have in my hand something I actually sent out to all of our members. This is straight from the United States Department of Health and Human Services, Office of Civil Rights. This is federal law that comes down about all the HIPAA violations. The question is, does the Health Insurance Portability and Accountability Act, HIPAA, privacy rule allow a covered entity to share the name or other identifying information of an individual who has been infected with or exposed to COVID-19 with law enforcement, paramedics, other first responders, or public health authorities without that individual's authorization? In short, the answer is yes. They can share that information. The HIPAA privacy rule, and I'm reading right from the Health and Human Services page, permits a covered entity. The covered entity would be your doctor and your MC, anybody who took the test. They're considered the covered entity. It permits that covered entity to disclose the protected health information of an individual who has been infected with or exposed to COVID-19 with law enforcement, paramedics, other first responders, public health authorities, which includes the county, the State Department of Health, the County Department of Health, and the county itself, without the individual's HIPAA authorization in certain circumstances, including the following. First, when it's required by law, which is an open-ended question. Second is to notify a public health authority, and this is the most important, in order to prevent or control the spread of the disease. That's pretty self-explanatory, that we need to find out who has it, who's spreading it, and your HIPAA coverage kind of goes out the window, because if you have it, we need to know who has it, who you've been in contact, and what do we do to stop the spread of this disease. That's pretty self-explanatory. Also, when first responders may be at risk of infection, us, the police, healthcare professionals, things like that, they need to know who has it. So in case they have to come in contact with you, it also stops the spread of the disease through first responders. That's pretty common sense. Also, when responding to a request for personal health information by a correctional institution or law enforcement having lawful custody of inmates or other individuals, where the disease could potentially be passed to inmates who may leave the facility, and then they leave the facility with COVID-19. A general consideration that must be taken with this is that it does not apply to all health conditions. A covered entity, as per this law, must make all reasonable efforts to limit the information used or disclosed under any provision listed above to that which is minimally necessary to accomplish the purpose for that disclosure. That means they can only talk about your COVID results because of this national pandemic. It doesn't mean that while they're on the phone with you, they could talk about other health-related issues that you may have. And if that ever does happen, that violates HIPAA regulations, and there could be legal action taken against the entity. If they disclose that you have heart disease, you have AIDS, you have some other disease, that is not covered with this. It's only covered under this pandemic.